Hi folks, welcome to Judicial Review this week. We're going to be looking at, I just want to make sure the screen is actually working here as I flip it over to our Judicial Review slide presentation that you guys have in your deck. There it is. Okay, I'm just going to assume everything's working and I'll go from here. So this week we're going to look at Judicial Review and the standards of Judicial Review. It's important to know that we are looking at this for the next 2 weeks. We're going to be looking at Dunsmuir this week, and then we're going to be doing some application of case law next week. And since we're doing judicial review, I am dressed in my, here I can kind of stand, I'm in my robe, like a judge, and I've got my gavel. And I know some of you are probably saying, why does Ken have a gavel? Canadian judges don't use gavel. They just use their voice to command the courtroom. Well, to that I say, gavels are really cool, and why wouldn't I use a gavel if I have one? And I actually did find this in a Canadian court. I don't know how it got there, why it was there, but there it is. Anyway, so here's me in my robe and my gavel, and we're going to discuss judicial review. So the first thing we'll kind of talk about is what is judicial review, because a lot of you who are taking this course, this is probably the first time you've even heard the term and don't really understand what it means. So what we're talking about is those cases which are heard by an administrative tribunal that are challenged basically on one of two levels, either procedurally or substantively, meaning that the procedure wasn't followed properly or facts of law or rules of law were not adhered to. And they challenge them on those respects. And we've looked at some of the reasons why people can challenge them already in the case law that you guys have done. What I'm going to talk about today is we're going to dive a little more into Dunsmuir and the changes that have occurred to the Dunsmuir framework in the last 3 or 4 months now. So late 2000, or late 2019, early 2020, we started to see the literature come out based on these 3 cases that we will get into, known as the administrative trilogy, that has really changed the way that we will be addressing standards of review going forward. But let's just go through the slides a little bit. We stopped last time with this chart showing where the federal courts versus the provincial courts. So depending on what tribunal you have, right, if it's federal or if it's administrative or it's provincial, it's going to take a different pathway. So that's just important to know depending on the tribunal you're looking at. So we talked a little bit about what that process is. And when we look at the cases, a lot of what will be discussed is this issue of jurisdiction. And it's not necessarily the way you may understand jurisdiction to be, because jurisdiction refers to the rights and the limitations of that, of the authority given to that tribunal. And so sometimes, even though the decision may seem unreasonable, it may not be a court's place to decide what is unreasonable. It may still stay within the jurisdiction of that tribunal. And so we'll look forward to see quite often when we see these challenges, they're done on a jurisdictional basis, saying, basically asking the question, who has the right to decide if this gets challenged or not? And remember, the point of the tribunals is to allow them to have enough power and deference from the courts to work independently, to come up with those decisions using the experts they have on their panels that make up their committees or whatnot, not to always be second guessed by the courts or for the courts to insert what they think would be a reasonable decision, because that is not actually their role unless it is what we consider patently unreasonable. And we'll get to that a little bit more as well. So for the past decade, we've been looking at Dunsmuir and New Brunswick versus New Brunswick. The details of this case aren't as important as what comes out of the case, as is typical with case law. So if you haven't read the Dunsmuir versus New Brunswick case, it's probably a good idea to do so now, or at least read through the case brief. Pause, we'll wait for you. You go ahead, make sure you read through Dunsmuir, New Brunswick, at least the brief, so you understand what's going on, and I'll just wait until you're finished there. Okay, so you can hit pause, or I'll just wait. Okay, I assume you've read it and you're back now, and we're going to move on. And so what you will have gathered from reading Dunsmuir is that the courts work on 3 standards of review. So if the courts are deciding whether or not they will intervene in a tribunal decision, they looked at 3 things. They looked at the correctness of the decision, they looked at the reasonableness of the decision, or they looked at what was considered patent unreasonableness. If you got to the end of Dunsmuir, and if you haven't, spoiler alert, they get rid of patent unreasonableness, and they decide to go ahead for simplicity's sake, because there's lots of confusion. Remember, we have varying size tribunals dealing with a variety of issues, and you're trying to paint with a single brush a multitude of cases that come up, everything from federal highly regulated things like the Energy Board to kind of the more minute, small ad hoc committees at the municipal level. So in doing so, we have to think of things in a very general term. And so what the courts came up with, what they decided was the best way to approach the standard review was coming up with these two things named correctness and reasonableness. And they judge those outcomes or the procedures of the tribunals by these two standards. This goes through, I think I just talked about Dunsmuir, what happened with Dunsmuir. And I'm going to let you're probably familiar with this because, of course, you just read the brief. But I don't want to get too much into it. What I want to stick with is the themes and the concepts that come out of this. So when we're talking about correctness and reasonableness, we are talking about two different ways in which the courts examine whether or not they will intervene in a case that stems from an administrative tribunal. And it's important to understand the distinction between the two of them because this is what gives authority to the courts to intervene. And as I said, even though they may deem it to be unreasonable, that is not always enough for them to intercede. Correctness almost always is. If things are not done correctly, meaning jurisdiction is wrong, or there's an issue at law, then they can intervene. Reasonableness is a different animal, and we'll discuss a little bit what that looks like, and you'll see in your case law this week that you guys are going to be discussing where that plays as well. Because reasonableness, well, it may not be as easy to define as correctness. It seems to be the way that we are heading in terms of how we will, at least initially, decide if there is reason for, see what I did there, reason for reasonableness for being applied, or if the correctness standard should be applied. So here we have these three great cases. And for those of you who are like, oh God, administrative law is so boring. Well, you're not alone. But secondly, the NFL, CRTC, Bell Canada, and the Immigration, Citizenship and Immigration Ministry against Vavilov create this really exciting area of administrative law. And I'll kind of go through each case a little bit, but really I want to talk about outcome more so than the cases. And I'll talk about Bell Canada and the NFL as kind of one case, because the background is this. Anyone who watches sports or the Super Bowl in particular knows that one of the reasons people watch the Super Bowl, it's usually for one of three reasons, right? It's for the game, it's for the halftime, it's for the commercials. What they had found in Canada was that if you had, let's say, Bell Canada or CTV, let's say you had the rights to the game. What they would do is, if you were watching the football game on a certain channel, they have what's called ad interruption. So they would take out the American ads and put in Canadian ads. And if you're watching it on a CTV affiliate network, that stands to reason, right? That's the agreement that they have. But let's say I want to watch the game on, depending on what network's carrying it, Fox, CBS, NBC, whoever happens to be carrying it that year. Let's say I watch it on that channel, and I'm not watching it on the Canadian. What was happening is Bell Canada was still interrupting those ads. So even though I wanted to watch it, I wanted to watch the American broadcast so that I could see the American ads, it was being interrupted. Well, there was a lot of complaints from the Canadian public about this. And so what ended up happening is the Attorney General, via the CRTC, decided that ad interruption on those American affiliate networks would not be allowed. Both Bell and the NFL had issue with this. And you can imagine why. Because they have contracts that are worth a lot of money. And if Bell has the exclusive rights to football in Canada, to the NFL in Canada, and you can skip over watching those Canadian ads to watch the American ads, Bell is going to lose a lot of revenue because the value of those ads drops exponentially. The American market doesn't care. They don't care about what's being broadcast to Canada. But in Canada, we care very much if people are watching Canadian ads. So this went to court. And the outcome was very interesting because the argument initially was that the CRTC absolutely had jurisdiction over doing this. That because they were the oversight body that they could do this. And what ended up happening is the courts reversed this, saying, no, this is not unreasonable. And in terms of correctness, you actually don't have jurisdiction. The tribunal has jurisdiction. The CRTC, like the government of Canada, can't come in and change what has already been agreed by the local administrative tribunal. And so in that case, we start to see, okay, well, where is that correctness standard? And in this case, they found that wasn't. And interestingly, for those of you who remember, this was in 2016, I think, we actually did for a year see the American ads. Ad interruption was not allowed, and that decision was since reversed, giving back what we call the deference to the tribunals to make their own decisions. And so that was reversed. So if you watched the Super Bowl this year, you probably realized, even if you were watching on an American channel, you did not get to see the American ads. You got the ad interruption, the Canadian ads. So let's fast forward a little bit. I think I'm getting ahead of my slides here. So we did talk about this, and you guys can go through this kind of at your own speed. I've got this on the site, but I kind of talked about it over that. And this, in an extremely rare opportunity to talk about things like foreign espionage in administrative tribunal law, is pretty exciting stuff. But we have this innocent, young man who is raised in Canada by his parents who turn out to be Russian spies. I'm not making this stuff up. This actually happened. When he applies for citizenship, they say, no, you can't have citizenship. And so he appeals this. Eventually, it makes its way to the federal court. The federal court says that the decision was correct, that they did follow procedure right, jurisdiction was right, everything seemed fine until the federal court of appeal overturned it, saying, yeah, everything was done correctly. Procedurally, it was fine. All aspects of law were fine, but this is not a reasonable decision. This kid grew up in Canada. Unbeknownst to him, his parents were spies, and he should not be made to suffer for the transgressions of his parents, basically. And so they, on the basis of reasonableness, they quashed that decision. And once it goes to the Supreme Court of Canada, the Supreme Court of Canada actually upholds this. So this is something different than what we just saw with the NFL. And so when we take these three cases together, we end up with something of, I want to say, some guidance from the Supreme Court of Canada as to where that standard review sits. And if you're confused, that's okay. It's confusing stuff. You may have to watch this a second time or look at the case law. But what that means is that we are finally getting some clarity. Not a lot. We're getting some clarity over what that standard review looks like. Is it going to be reasonableness? Is it going to be correctness? And if these words are starting to sound like word salad, let's go ahead and talk a little bit more about what constitutes reasonableness and correctness. Because I think once you understand what those terms mean, we can start to look at case law and decide, A, has it been a reasonable decision? And if the answer to that is yes, but the correctness is flawed, in what nature is the correctness flawed? And if it's not flawed, it's no longer the jurisdiction of the courts. It stays with that tribunal. Remember, the tribunals have a lot of discretion. And in the casework you guys looked at last week, you saw that with both Baker and Boucher, that the courts have, or the tribunals have, a great deal of discretion. And jurisdiction is a big issue. Even though things may seem like they were done wrong procedurally or otherwise, if there was bias, we still may not be able to wrestle that case out of the administrative tribunal if it is seen that it was done reasonable in their regard. I'll give you an example. There was a young woman, and I don't exactly remember the aspects of the case, so if you go to look it up, you won't find it, but it's a young woman who has her license, and her license, she is caught speeding or something. She gets a ticket of some sort. Anyway, what the Ministry of Transportation does is they revoke her license and say she is suspended for a very long period of time. And I can't remember. We'll say it's a year and a half. And so she argues this. It goes through the tribunal, and eventually they argue it outside the tribunal on a judicial review, saying that even though everything was done correctly, jurisdiction-wise was correctly, procedurally it was done correctly, it was not a reasonable outcome. And the courts agree, saying, yeah, this isn't reasonable. You can't suspend someone's license for a year and a half or however long it was. Once it then gets appealed, and the decision is this. Yeah, it might seem a bit unreasonable, but that is not the court's decision to decide. It is not their jurisdiction to decide what is unreasonable. It is clearly within the discretion of the Ministry of Transportation to decide what is reasonable. Remember, they are the experts in the field. They're the ones who make that determination. The courts cannot just play big brother and second guess everything. I mean, they can, they just can't do it in an official capacity. They can't then take the case away from the administrative tribunal. So in that case, it got sent back, it got overturned, and the outcome, the remedy that was given by the administrative tribunal, it succeeded. And so that young woman did in fact lose her license for 18 months or whatever that time limit was. So it's important to understand that those tribunals do have the ability, and over the last decade, 12 years or so, this has been a wrestling match of where is that standard? When does the court get to intervene? Because the courts undoubtedly will not always agree with the decisions made by the administrative tribunal. They're coming at it from different points of view. One is a body of law, the other is a body of expertise in the system. And you may have opinions on which one we should listen to, but the courts and the legislation is interested in deciding how much deference do we give to the administrative law, because that is the first place. We want them to really, in a perfect world, it would never go to judicial review. Things would always stay within the administrative tribunal. They would handle their own business. And these three cases we're looking at, we start to look at, okay, when are we going to intervene? When do we say the administrative tribunal system has failed and it needs to be taken over in a case-by-case basis by the provincial government or the federal government, depending on which tribunal it is. So when we're looking at reasonableness, again, we are talking about things of more of a conceptual nature, I suppose. It's more abstract. I've highlighted a few things here, like we want to make sure that there is justification behind it. There's transparency behind the process, that it was that the decisions were given with reasons and a rationale that we can all appreciate. And again, there is a wide berth of discretion, but you can be unreasonable in what you choose, and so we want to make sure that those decisions were raised. And we've gone through a little bit in the last class, in the last set of slides, what might constitute things like bias or prejudice in the system. But reasonableness really looks to what those outcomes are, but it does also look at the reasonableness of process. And one of those areas you could maybe think of is in timeliness. Was there reasonableness in timeliness? And it starts to get a bit confusing, but think of reasonableness as more as the kind of conceptual model of does this seem to make sense? And it doesn't have to be perfectly make sense, just falls within the realm of reasonableness. Far more easier to understand is the concept of correctness, because correctness is much more concerned with the aspects of law and the nature in which we are applying it. So maybe to me and maybe to you as well, one of the most obvious areas here is things like constitutional law issues. Because if it's a matter of constitutional law, this is something that will have to fall outside of an administrative tribunal who is not steeped in constitutional law, but send it to a federal court that is. So that makes sort of sense, right? So if we're looking at what is the correct standard and it's a constitutional law issue, depending on what section you're looking at, you may say, okay, this is well outside the scope of the administrative tribunal, or in trying to apply it, they have not done so correctly. Another one that's maybe obvious is when you have two separate tribunals who are in dispute. And this does come up from time to time as well. So the correctness might be who has jurisdiction over this sort of thing. And then what else do I have on here? I think that kind of covers those four things. But it really deals with areas of like the rule of law. It deals with the ability to correctly identify who has jurisdiction in a certain situation. That is far more clear than reasonableness. Reasonableness, again, it's far more conceptual and has to be placed in context. Correctness kind of applies everywhere. It's for every case. It's who has jurisdiction over this, and if there's two groups that claim jurisdiction, that's when we need the courts to intervene and look at that. So we can easily see where correctness is brought in. I think more easily so than reasonableness. But the changes that came with this administrative tribunal, I'll say they simplify it, but they simplify it in a way that seems to suggest that our presumptive approach is that of reasonableness. And let's just see. Okay, so this talks about how not everyone was thrilled with what came out. People were looking for a lot more guidance than maybe they got. But what is interesting about what came out of this is it seems to be reasonableness will be the approach that is taken unless it can be rebutted by reasons of correctness, such as constitutional issues, such as jurisdictional issues between two tribunals. Otherwise, they will look at it first as a standard of reasonableness. And I think that is all I want to say on that, because it does get kind of complicated, and I don't want to muddy it more than that. I think it's worth looking at the slides, even if you look at it separately from this video, to get an idea, because understanding what the difference between these two approaches is very important, particularly since the changes that have come along. And we'll look at some case law that had been very important, but maybe now will be less so based on the outcome. So the first one I want to look at is Feebles. Again, without getting too much into the case, we have someone who was convicted of a crime that in both in Canada and the US. And basically, if you commit a crime in another country that is a crime within Canada, then that's considered a crime. The reason that might sound obvious, however, you can imagine, let's say someone was fleeing a country where they were a political criminal. If they had that crime on their record in Canada, we would not hold that against them. Like being a dissident or speaking out against the government is something that it's a tenet of democracy for us. So we wouldn't, if they had a criminal record because they spoke out against a government, we wouldn't hold that as a crime. However, in this case, I believe there was a knifing involved. So both in the country it was committed and in Canada, it is considered a crime. But aside from kind of those aspects, basically what Feebles is asking for is to be able to stay in the country, and they do make the appeal is made on kind of this humanitarian grounds, because we know that from a correctness standard, this will not get overturned by the administrative tribunal, who in this case is Citizenship and Immigration. And when it goes to judicial review, one of the things that I just want to see if I've got it on the next one here, one of the things that they want them to look at is the fact that they've been in the country for some time, and it would be great hardship to send them out of the country and back where they could see severe punishment. Here's the important distinction. It is not, and it being Citizenship and Immigration, is not obligated to look at that information. They have the discretion to decide whether or not they want to. So one may make a humanitarian argument, but the tribunal is actually under no obligation to include that or to have that sway their opinion. And this really speaks to the ability of that discretion. So if we were to apply the new Dunsmuir framework, this would still hold up. This would still give, we might say it's not reasonable, but it's only reasonable as that which we find relevant, which if the tribunal finds this is not irrelevant, then they may choose to exclude it, right? Now, if the language is changed to shall, like we saw in some of these earlier legislative rewritings, that makes a difference. But for now, that is still the case. So Feebles would still not have to conform to the conventions of the UN, as we see here, for protection of Canadians. So sometimes we might look at something and say, okay, well, that's the statute. And amazingly, the tribunal does not have to consider that statute unless it is something that it supersedes their ability as a administrative tribunal. For instance, if the language said they must consider aspects of protections for the refugee board. Okay, and then the dissenting opinion here by Abella and Cromwell said that they think it's basically inhumane what they're doing by not taking into consideration here. And again, would this fall under that reasonable category? I don't think it would. I think this would still fall under the correctness standard, and that the feebles would still be sent out. So let's move on to Peace River Coal and CN Rail, because this one, despite all of this, which you can kind of read through, I'll give you the basic gist of it, is you have the rail company, and they're paying a tariff enforced on them by the Canadian Transportation Act. So basically you've got the CN versus CTR, the CTA, and things change. You know, the details aren't that important, but things change that it should favor CN, but the CTA says, no, we're not going to allow this cheaper rate, even though everyone else is getting the cheaper rate. We're not going to allow you to get the cheaper rate. And so the CN Rail decides, well, we're going to challenge this because we don't think this is fair. Only to find the CTA in their administrative tribunal says, yeah, it's perfectly fair. This is well within, this is what you agreed to. And so this is what you're stuck with. So CN, not satisfied with that, they decide to go outside, and they go after what we're calling the Governor in Council, which the Governor in Council is basically the Governor General, Attorney General acting on the cabinets, the Canadian, the parliamentary cabinet, on their wishes, right? I mean, that's basically what they do. So the Governor General decides, or the cabinet, we'll just say the cabinet decides, yeah, this is not reasonable. This is kind of silly. Why would we be making them pay more when things have changed? And it becomes a question of jurisdiction. So let's look and see where, you know, if you're CN Rail and you've got friends in cabinet and you're saying, hey, the administrative tribunal is saying they're not going to lower our prices, and that doesn't make any sense, and your buddy in cabinet says, yeah, I agree with you. Does your buddy in cabinet have the jurisdiction to disagree or overrule the decision made by the administrative tribunal? So let's see what they said. So initially, the federal court says that it's jurisdiction and that it has nothing to do with the Governor General. So it goes back to the transport agency's decision. And then the Federal Court of Appeal flips on this and is saying, no, but if we look at this from a reasonable standpoint, then the CTA is incorrect and we will side with CN Rail. So then we have to go to, mom and dad at the Supreme Court to try and solve this quibbling. Whoops. And what do we find? We find nothing. Okay, there we go. So what they find is that there is no express limitations on the jurisdiction, meaning that it is possible for the Governor General to be part of an interest party in this petition, and that administrative framework instituted by Dunsmuir doesn't just apply to the tribunals. It applies to every government body, basically, which would include the Governor and Council. And so if that is true, if the limitations of Dunsmuir are that broad, then they may intercede in terms of what is considered reasonable. So as you can see here, we go through what the considerations are, and when we bring in regulatory legislation, that Parliament can be recognized to be familiar because they'd be considered experts in this, and that there's historical experience and economic regulation. So remember, one of the things with the tribunals is we want expert involvement in this. And so one of the reasons that the cabinet is involved is they would be said to be, in terms of creating reasonableness, is they bring this expertise to it and not getting caught up just in correctness. This would maybe not seeing the forest for the trees, is that it's reasonable to reduce the fees or the pay for CN, despite the fact that everything was handled correct. Now, I put at the bottom here of note that with the new standards, this would be an issue of correctness. And the reason being is because what we look at is legislation that extends outside. And the second part, typically, it's not just what the jurisdiction explicitly says. It also has to do with, is there going to be policy at large that will affect? It could be the greater political landscape or the economy. And in this case, You could argue both, but certainly from an economic standpoint. So I think even this case, if it went under the new standards, it would still hold up. We just might look at it from a different type of review. And then there's some more follow-up to that you can look through, saying where that line stops of Dunsmuir. How far-reaching is it? Okay, so why do we care? Incorporates cabinet's administrative functions into the Dunsmuir framework and lays out checklists for lower courts. So what we have here is the questions of law and how things are done as a whole, right? We're not just looking at the system as fragmented parts. We're looking at how it functions together. And if the governing council is part of that, Dunsmuir extends to that as well. So what this brings us to, I think that's the last slide. So what this brings us to is next, or this week coming up, we are going to be looking at administrative tribunal for the Trinity Western University's application for a law school. And as many of you may know, Trinity Western University makes their students and faculty sign a covenant, or it did at the time. We're going to talk in terms of relevance at the time. They had to sign a covenant naming or enlisting a few things, such as they would not engage in premarital sex or engage in relationships with members of the same sex or gender. Basically, it's a Christian university that was instilling Christian values as they see them. So when this went through, so the law societies of a number of provinces, Ontario and BC being two of them, they challenged that the tribunal was not handled fairly because the law societies in different areas in BC and Ontario did not come to the same conclusion in terms of whether or not they received procedural fairness. The question is, on what standards should it be reviewed? And the reason that I like doing this case, and I'll kind of kill two birds with one stone here, is it asks you to put those personal opinion, those feelings aside and look at this strictly as dispassionate law decision. I'm not asking you to agree with Trinity Western University's philosophies in order to support the fact that they did not get procedural fairness, if that's what you've come to determine or if that's what your side agrees on. There is no need to say we don't agree with Trinity Western University's philosophies. However, leave that out of any arguments you have. Simply do it based on points of law. Is this something that they would have received procedural fairness? And you can look at the case law, because the question we're asking this week is, had the Dunsmuir framework been changed and updated with this administrative trilogy, would it have been a different decision? Because after it was in, I want to say New Brunswick, and I can't remember now, but Ontario and BC, they were unsuccessful at two, but they were successful with the upper, I believe it was Upper Canada decision, and then it went to the Supreme Court, and the Supreme Court eventually said that they did receive a fair hearing, and that based on discrimination, they were not able to, they were within their rights to deny them access to the law society or to be given the ability to run the law school. So to this day, Trinity Western does not have a law school. I'm not sure if they're still trying to pursue it. They have dropped the student covenant as far as I understand, but the faculty one still exists. Those changes could be occurring, dynamically as we speak. So I'm not exactly sure. But what your job is for this week is to look at that case, the BC case in particular, and decide whether or not, based on the new standard, presumptively reasonableness, and then second, correctness, if it should have undergone judicial review or if it should have stayed at the administrative tribunal level. And that's kind of your task for this week. It also is important to note that the readings that you see for this week are for the next 2 weeks, because you can see there aren't readings on Moodle beyond whatever week we're in, week 7. Are we week 7? And for week 8. Also note, there is no quiz this week. The quiz is not due until the end of week 8. You can do it at any time. It's open. But it's actually, maybe it's not open. I may have lied about that. It may not be open until next week, but either way, it's not due until I think it's the first week in, or the second week in June. And then there's only one more quiz after that. But check Moodle and see where that is. So that's it for judicial review. If you have questions, please post them on Q&A. I find that judicial review and the standards of review are probably the most difficult and complex that we deal with in this course. It's okay to be confused by it. It's a confusing topic. The best thing I can suggest is understand the difference between correctness and reasonableness. Understand those concepts separately and then look at case law. If you look at case law without understanding what those two things are, you're definitely going to be lost. Okay, that's everything. So good luck this week on your forum posts. And I'm trying to exit out of here as gracefully as possible. And I'll give it a little whack of my gavel.